Are you Nir Brown?
I didn't agree. I'm sorry. We were here before.
You've been here before, but you have to speak up where I can hear you.
Execute beneficiary of the trust in hand.
Of the trust of what?
Of the trust in hand, yeah.
Of the trust in hand? Whose
Yes.
hand? What trust?
Execute.
Did you bring a copy of it?
I wasn't able to get to the cop. I do
Take the glasses off. I need to see your eyes, please.
These are my prescription glasses.
That's okay. So I'm having a hard time understanding you. You need to speak up and speak clearly so that the record can be clear. You were already here and I gave you an opportunity to try to go hire a lawyer for your two cases. Did you get a lawyer hired?
Able to do it.
Who'd you talk to?
Made a few calls to the guy, Rafe. What's his name? Rafe King?
Mm-hmm.
What's his name again?
Who else?
That's the lawyer that I chose.
So if you chose him, you should have gotten him high. I mean, he has the same, there's somebody that answers his phone every week. I understand. I know how it works. I told you to hire someone or visit with at least 3 lawyers.
Made an attempt.
You made an attempt? Okay. Did you go see Mr. Kimler? Did you make an appointment?
Able to do that.
Why not?
I'm not in a position to go back and forth in front of a lawyer that's in this state that I'm not filing. This is falling age.
So here's the thing, Mr. Brown, I told you very specific instructions when you were here before that if you did not do what I asked you, then.
This is exactly why courtroom orders matter. The judge had already given Mr. Brown a clear assignment: consult with multiple attorneys before returning to court. When the court believes its instructions were ignored, the consequences can be immediate. Watch what happens next. This isn't about winning an argument, it's about complying with a judge's order. Would you keep arguing, or start listening?
And your bond would be raised and you would have to go back to jail, right?
No.
Yes, that's exactly what I say, because you've heard me say it probably 8 times already this morning. So at this time, Mr. Brown, because you did not do what I asked you to do or what I ordered you to do, I'm going to raise your bond.
Challenge subject matter jurisdiction.
That's overruled. Listen, Mr. Brown, I'm raising your bond to $100,000 in each of your cases for not following the court order. Go back with the bailiff. Go back with the bailiff. Go back with the bailiff. You're going to make it worse if you don't.
Yeah, respectfully, this is not a fair trial.
You don't get to say respectfully and then be disrespectful. Go back with the bailiff.
She started an
Don't make me lay hands on you,
Why would you lay hands on me?
because you're not doing what I'm telling you. Now go.
Mr. Brown,
She go
you
back.
need to go back with the bailiff. Right now, I've raised your bonds. You have to go with the
I am not
bailiff.
a threat to any officer.
You through in, Judge?
Yes, I'm through.
I am not a threat to any officer.
Let's go.
Why are you hands on me?
Yeah.
Why are
I
hands
told
being
you. I told you I was gonna put hands on you.
Why are hands being put on? Y'all see this on the camera?
Right there. Put your hands on. Okay. Put your hands.
What a dramatic ending. Once a judge issues a lawful courtroom order, refusing to comply rarely helps your case, it usually makes things worse. And just like that, we move from a heated courtroom confrontation to a completely different legal issue, a bond hearing involving a firearm allegation, where the court has to balance public safety with the defendant's constitutional rights.
No walk, but you're not listening. Listen, I don't buy that.
Good morning, sir. You're Dan Church.
Oh, yes, ma'am.
And this is 26 DCCR 0612. Mr. Church is charged with deadly conduct, discharging a firearm. And the state has filed a motion asking that, well, I'm looking at the state's motion. The motion it says aggravated assault, but the charge is deadly conduct. That just
I'm sorry, Judge. That's my error. I was
Okay.
trying to file it rather quickly after receiving the affidavit from the complainant, and I'll fill the court in on that as to why I don't have a witness present.
looks like the current bond is set at $20,000. The state has asked to raise that bond. Ms. Malfino?
Excuse me, Judge, and I apologize about that error. Obviously,
That's fine.
the court would see the probable cause affidavit. It's very similar to an aggravated assault, discharging a weapon, someone in the direction of the complainant. In this case, I have had multiple conversations with Jeremy Shelton, the complainant. He is the across the street neighbor of Mr. Church. He is a very nice young man. He was very forthright, came in and presented me or had an affidavit authored by himself with one of my investigators in lieu of coming to docket today. He, as the court can probably surmise, is of the mind that he doesn't want to aggravate the situation nope, not intending to use that same word, but I will tender that as State's Exhibit number 1, just for purposes of this hearing, and I have Mr. Gertz, it's his affidavit just expressing concern about the nature of this offense and the fact that they reside across the street from one another, that he has a very young son and a wife who were also present at the time of this offense, and he has concern that Mr. Church may be keeping weapons at his sister's house down the street. I have worked very closely with my investigator, Mr. Fays, and he is familiar with Mr. Church as well as Port Arthur Police Department is. And we've asked that some things be implemented in the interim time period to hopefully assure the safety of all the parties, including Mr. Church. I just wanted to bring this matter to the court's attention with that motion. It's not necessarily intended to increase as much as it is to modify the admonishment regarding weapons, etc., because obviously it's difficult to remove these two individuals from one another approximately because of where they both reside.
Any objection to me reviewing that?
Well, Judge, the rules of evidence don't apply in a bond hearing, so I would love to have some great evidence, but I don't have a good one.
Here's where bond hearings get especially interesting. The defendant hasn't been found guilty, so the court isn't deciding guilt or innocence today. Instead, the question is whether the current bond conditions are enough to protect the community and ensure everyone stays safe while the case moves forward. It's a careful balancing act between individual liberty and public safety.
Now, State one's admitted for purposes of this hearing. Give me just a second, please. Mr. Gertz?
Judge, I'm happy to discuss bond conditions. $20,000 is more than sufficient, though, in terms of amount for this allegation as it stands right now, or as it's indicted right now. Mr. Church wouldn't, I think, object to the normal conditions of not having any contact with the complainant, not possessing any weapons.
Those are already conditioned.
Right. I'm not sure what else. Given what else the court could impose, because of the proximity of their homes, without infringing on his constitutional property rights of his own. But I think the fact that he's hired counsel, has shown up to court, he's taken this seriously. He's not been threatening the complainant or anything of that nature. I understand the complainant may have concerns, but those are the complainant's concerns. They're not being triggered by anything, no pun intended, by anything that Mr. Church has done since his arrest or his indictment. And so, and he's not violated any of his bond conditions that
I think
that I'm aware of. Or that
is if they feel like he is watching, could be, just uncomfortable. There's an allegation that he's sitting in his car watching family. Obviously based on the nature of the offense and the allegations and the probable cause, that would give me some concern too if I lived across the street and that had actually happened. So,
but I just don't think raising his bond and just charging him more is a question.
Listen closely to the judge's reasoning. The issue isn't just direct contact, it's any behavior that could reasonably intimidate or frighten the alleged victim. Even if someone never says a word, actions like repeatedly lingering outside or closely watching a complainant can raise serious concerns. Small decisions outside the courtroom can have major consequences inside it.
Is the proper remedy for that? So I'm not sure how the court remedies that, and I don't see what
the way it gets remedied, Mr. Church, is if you're doing anything that's making the person uncomfortable, that's the complaining witness in this case, the only way for me to take care of that is to put you in jail. Then they don't have to, nobody has to worry. I don't want to do that, but I need you to understand that there's no way around if, you're not contacting them or talking to them. I get that. But if you're doing other things, like sitting in your car and watching them, then that's going to be of concern to me. So I'm ordering you, here's what I'm ordering right now. Listen to what I'm going to say very clearly, okay? This no contact order is going to include literally looking that direction. You can't sit on your front porch. You need to sit in the back. You can't just sit in your car for no good reason. People don't do that, so you're not going to do that. Do you understand?
Yes, ma'am.
So if they feel uncomfortable, they're going to let Miss Malfino know, and you're going to end up in jail. So I understand you live across the street, but if I were you, I'd walk. If I was going out my front door, get in your car and leave if you're going somewhere. No lingering, no looking that direction, no standing there watching.
The judge ultimately leaves the bond amount unchanged, but the warning couldn't be clearer. Freedom before trial comes with responsibilities, and violating bond conditions can land a defendant right back in jail. One case showed how ignoring a judge's instructions immediately increased the stakes. The next shows how respecting court orders can make all the difference. Which decision do you think the court handled better? Let us know in the comments.
Otherwise, you're going to end up in jail because I won't have any other choice. Does that make sense?
Yes, ma'am.
Okay. So we'll reset this for an announcement. Make sure you stay in touch with Mr. Gertz, visit with him before that next court date, and we'll see if we can get an announcement, okay?
Yes,
You're
ma'am.
free to go.
Okay.